SJC-12039, Commonwealth versus Santana.
Good morning, Ms. Caddick.
May it please the court, Elizabeth Caddick for Cesar Santana. Don't worry, your statements aren't going to be used against you in court. We're going to help you. Sandwiched in between those two statements was a pro forma reading of Miranda warnings. Those Miranda warnings did not dissipate the promises made to Santana that his statements would not be used against him in court. He specifically said, yes, I'll talk to you if my statements won't be used in court and they'll be confidential.
Did he say that before or after he got the Miranda warnings?
He said before the Miranda warnings, I'll speak to you as long as it's not used in court and they're confidential. And he was told, don't worry, they won't be used in court.
And then he got the Miranda warnings.
Right.
And did he reiterate what he had said before?
He didn't, but the detectives, in fact, reiterated by saying, Detective Cuevas said, we're here to help you. We're going to go to the judge and the prosecutor and say, you helped us, we're going to try to help you.
Could I just, maybe I'm just quibbling, but he's the one who said, isn't he the one who said, as long as it can't be used in court? And so you're saying when Detective Cuevas says, no, do not worry, that's meaning, no, it won't be used in court.
Right, right.
Can you back up and give it some context as far as what was going on with the probation officer and how they first got there to frame the entire statement?
Okay, well, the crime had occurred on a Sunday. On Monday, Santana met with his probation officer in Boston, and he said to the probation officer, there is an incident up in Lawrence. I have some information about it.
So he went from New York back to Boston on that Monday?
Well, he never said he went to New York.
Wasn't that part of the evidence that he did go to New York? No.
Well, it was in Carson.
Well, in any event, there's no question but that he met on August 26th with his probation officer.
Right.
Okay.
Right. Jessica Incarnation had said, well, her third time, she said one thing the first time, one thing the second time, and then the third time, years later, she got things really great that were prejudicial towards Santana that she just didn't say before. And one of them was, he drove us to New York that night. Okay. So I will say that the probation officer had the dates down when he met with Mr. Santana.
On the 26th?
I don't remember it being an issue, that it was the day after.
Okay, that's fine.
Right.
Move on. It's my fault. Sorry.
Okay. So there, nothing came of that, substantive. And then in March, about 4-5 months later, Mr. Santana is arrested for another crime, is being held in custody in jail in Boston. And he again says, I have information about this murder, and I wanted to talk to someone about it.
And when did he ask for money?
Money? Well, there's nothing in the
The Commonwealth says that he wanted to get paid for the information.
Well, I'm not quite sure where that evidence came from. Certainly not in the interview that he wanted to get paid. In fact, the Commonwealth in its brief claims that the only reason Santana wanted to talk to them was because he was afraid of Junel Garcia, and that he didn't care whether his statements were going to be used against him at trial, which of course is absurd. No one's going to be comfortable that someone they're afraid of is not going to harm them because they tell the police about his crime and he'll be arrested, and then not care that he'll be charged and have his statements used against him in court that would make him liable for first-degree murder. And in fact, it's Santana's own words that said, well, I'll talk to you as long as they're not used in court. He didn't say as long as you don't tell Garcia.
Now, maybe these are just labels, but is he there as an informant at this point?
I don't know that he was ever labeled an informant. As far as I know, he wasn't called an informant. We don't know anything. I know that
Trying
there
to
were...
get the purpose for which he reaches out to the probation officers to give information. Is he looking for something in exchange for that? Like help on his existing case?
You know, it's what we have in the record is simply that he wanted to talk to them to have them be able to fill in the pieces, the missing pieces on what happened in this crime. Certainly there was no argument by the Commonwealth that, oh, he was just trying to get some money or trying to get a benefit in another case. What the Commonwealth argued was that he's trying to limit his liability by claiming that he just brought some guns up to Lawrence from Boston the night before the crime, and that he was asked to pick them up after the crime at the apartment building, but was just outside downstairs. So that's what we know. But the important thing is that with the two judges who heard the motions to suppress, there was one motion to suppress, there was involuntariness that was raised, there was a full hearing, there was a translation of the interrogation where it was clear that not everything the English-speaking detective was communicated, and in fact, statements were miscommunicated to Santana. The court, in rendering its decision, just talked about the Miranda warnings and whether they were proper, and said, well, since he wasn't in custody, it doesn't matter, but they were okay. So the third attorney filed a motion to exclude the statements, asking the judge to focus on the issue of voluntariness. And that judge did address voluntariness, but incorrectly said that the Miranda warnings dissipated the promise that the words wouldn't be used against him in court. But this court has multiple times listed all the factors that go into voluntariness. There's 12 factors. Miranda warnings are just one of the 12. And has certainly said that Miranda warnings alone do not determine whether a statement is voluntary or not. The trial judge seemed to think it was important, and so did the Commonwealth, think it was important that the promise was before the Miranda warnings, and the Miranda warnings were then given. A couple of responses to that. One is, it doesn't matter. There's no case that says, oh, everything that was said before is dissipated because we have these pro forma Miranda warnings. No one said to Santana, look, we're giving you these Miranda warnings, and let me make clear what we just promised you. We take that back.
Can I just ask you this? I understand your first part, and put the Miranda warnings aside. But as the interview goes on, and there's the exchange about, Trooper Labarge says, you need to look out for yourself, and there's a somewhat lame translation of that by the detective. And then your client says, Cueva says, he's telling you that you want to take care for yourself. That's your first thing. You want to come out well from what's happening. And your client says, of course, the problem is I'm not worried for telling him and the police what I got to say. Understand? The thing is, the one up there. So I guess what I'm getting at is, it seems to me that one way of reading the whole exchange, or understanding the whole exchange, perhaps, is that as time went on, he, that is your client, was indicating some awareness that, and not caring about the fact that, yes, the police may use this in a variety of ways. That's okay, because I'm worried about, I'm just blocking on his name. Garcia. And, you know, here I am and I want to keep talking.
No, that's the reason he said, I think the record shows the reason he said, I'm not worried about what I say to him because I already had an assurance from you it's not going to be used against me in court. So why would he care? He's already been told, we're not going to harm you. If he didn't care that it was going to be used against him in court, he wouldn't have said, I'll talk to you as long as it's not used against me in court, as long as it's confidential. Nothing occurred that would have made him think.
So the passage of time in the conversation is really what I'm getting at, and maybe it doesn't, but it just seemed to me that there was a whole lot of exchanges between that first conversation and these later statements.
Well,
that were before, you know, the inculpatory thought of anything.
I think that there was not a long period of time. It's not as if he was assured that there was confidentiality. Then they broke. They came back the next day. They read the Miranda warnings. Even in United States versus Rogers, which is the case similar to this, where he was promised confidentiality, and then federal agents came in the next day, read him his Miranda rights. He made inculpatory statements, and the United States Appeals Court said, well, they can't be used against him because he misunderstood the import of the Miranda warnings because he had been told the day before that what he said wouldn't be used against him, and nothing changed. And that was even the next day, and that wasn't enough to dissipate the earlier promise. Also, this court had decided in a case where the defendant had been illegally arrested and got his Miranda warnings and then made a statement that was incriminating. And this court said that his statement should be suppressed, even though he got Miranda warnings, because there was no break. There was only about an hour's time between the time he was arrested to the time he gave his statement after Miranda. And so it was still, the effect of his unlawful arrest was still in play. It was a short period of time. Here it was less than an hour, I would think, when you read the transcript, between the time he was given those assurances and made the statement. And, you know, as this court has also said, that a confession is really the most incriminating evidence that can be used against someone, and certainly his statements were used against him throughout trial, and it was, and even the Commonwealth had said that his statement is a very important piece of evidence against him. And it was fully preserved, so it is up to the Commonwealth to prove that it was harmless beyond a reasonable doubt. It was certainly enough to convict him of joint venture. There was a joint venture instruction. And so the Commonwealth also had argued, well, the defense counsel wanted to use his statement. Well, he certainly didn't. There were 3 defense attorneys who attempted to suppress this statement.
I mean, using your point is, yeah, wanting to use his statement at trial once the motions to suppress had been denied.
Exactly. He was trying to make the best of a bad situation and trying to say, oh, look how much he was cooperating. And exactly. And the other The other issues that were preserved that render this even more prejudicial, one was that the trial court did not give a DG Batista instruction, even though it was requested.
But on that point, I mean, given that the defense was, let's assume no error in allowing in the statement. So the defense is built on the "I was outside" piece. So insofar as the defendant, I think, I'm not disagreeing with you that there certainly is a very strong argument that DG Batista instruction should have been given. But in terms of whether it was the kind of error that would be reversible, when the defense, this is the Commonwealth's argument, but when the defense was really built on pieces of that statement that the defendant made, and he asked for it not to be recorded, I'm just trying to see where the reversible error comes from.
Well, because the instruction tells the jury, this isn't taped, so whatever the police tell you, you need to look at with a suspicious eye, that you don't necessarily give it full credit. And so
Wasn't this piece of it taped anyway?
part of it was taped, but nothing that, right, but of course, even though part of it's turned off and part of it's taped, of course, they're still entitled to the instruction.
No,
Right.
I know that.
But and I think it's particularly important here because his statements, were not voluntary, but also the accuracy of them it was contested because we know that what Cuevas told Labarge wasn't necessarily accurate, or what Cuevas told Santana wasn't necessarily accurate. So we have what could be, inaccurate rendition that Labarge took down in his notes and told the jury. So that's a perfect reason to have a DG Batista instruction that, well, look, you're not listening for yourselves as to what's going on. So, consider it with a grain of salt. And so this is the particular type of case. And also, that was a preserved error. It also proves more prejudice to the suppression error. The other issue had to do with, since the defense was he was not in the apartment, the court did allow in improperly the accusation, or the statement. Wasn't just an accusation, it was a statement by Labarge that he told the jury. He said to Santana, "I've been talking to people and they say you were in the apartment." And
Is that what the trial judge, Judge Lowy, said gave a limiting instruction on that?
he did. He said that the police don't know that what people say to them is the truth, and police use certain tactics.
And didn't he also sort of say it's only admissible for you to consider the answer about the outside?
No.
Wasn't
Oh, actually, I don't.
I
I don't remember, because this was not a case. This was the case where it was a denial. It wasn't an admission, right? It was, you were in the apartment. No, I was outside. That's a denial. So it should not have come in at all. It's not an unambiguous denial. It's a clear denial. I'm accusing you of being in the apartment. No, I was not. But it's not just I'm accusing you. It's other people told me you were in the apartment. So it's hearsay. It's an accusation that was denied. It really goes to the heart of the defense, which was I wasn't in the apartment, because the judge said the only way that Santana could be convicted of extreme atrocity and cruelty is if he was in the apartment. And so here we had no witness at trial say he was in the apartment. We had no confession saying he was in the apartment.
Well, don't you have DNA inside the apartment?
Excuse me?
Don't you have DNA inside the apartment?
Right. Well, we have DNA inside the apartment, but we have a couple of things. One is there were two people's DNA on that tape.
But he's
Including
the
your
major
clients.
profile.
Right.
Your client was the major
He
profile.
was, but even the Commonwealth's DNA expert had said, well, you don't know who was the last to touch it. The major or the minor profile person. Also, you have his statement that he did bring a bag of items up to the defendants, the assailants, the night before, and the trial attorney was able to get out that, well, you could either touch something and put your DNA on it, or you could touch something else like a piece of paper, and that could touch something and your DNA would be on it. So there was some explanation as to how his DNA could possibly be there. But certainly it's a confession that is the strongest evidence.
Okay, thank you.
Thank you.
Mr. Steinfeld, good morning.
Thank you. May it please the court, Kenneth Steinfeld for the Commonwealth. I'd like to begin by going over the sequence of factual events that concern the probation officer, which Justice Gaziano brought up, because it is complicated and it is important. The murder occurred after midnight on the 26th of August, 2004. According to Jessica Encarnacion, that night, she and the defendant and two other people went to New York and then drove back. That afternoon, on the 26th, this defendant went to West Roxbury District Court for a prearranged meeting with his probation officer, Brad McNichols.
So he came back from New York?
Yes, he came back from New York. The evidence, the testimony from Jessica was that only Junell and his girlfriend got on a plane to go to the Dominican, presumably because Junell was the shooter, which was the Commonwealth's theory both at his trial and at this trial. So that puts this defendant back in the Commonwealth that day. He went to see Brad McNichol, his probation officer, that day, and he also met with him about 13 days later on September 8th. And the probation officer testified that at one of those dates, he was not sure which, that is the day of the murder or 13 days later, both prearranged meetings because he had to check in every 2 weeks with his probation officer. The evidence at the suppression hearing was that he was about to be violated for his probation because he was in a batterer's program, and didn't have the money to pay for the program. So on the 26th or on the 8th of September, he said to his probation officer, "I need money to help so I won't get probated so I can pay for this batterer's program. And I have information that I can give to you about a shooting in Lawrence for money." So it is plain that that first disclosure that he has information to his probation officer is in exchange for money.
Well, because he's got a required program that he doesn't have the money to pay, and we're gonna, okay.
No, I'm just explaining why he makes the disclosure at that time to the probation officer. I'm not putting any judgment, any value. I'm just explaining factually that's what the testimony.
I don't get the
What?
money part still, excuse me.
He goes to visit his probation officer, and he fears he's going to have his probation revoked because he has not paid the fee for the batterer's program that is a condition of the probation. So basically, he wants the probation officer to,
Get it waived.
yes, or to somehow make it go away, make that financial problem go away. That is, his probation being revoked because he doesn't have money for the batterer's program, and in exchange, the defendant is offering some information about a shooting in Lawrence. And that happens either on the 26th of August or the 8th of September. Now, on March 4th, 2005, the defendant and Garcia have been arrested for a Boston home invasion, and they're at the Nashua Street Jail. And State Trooper Bob Labarge goes there, and he has two pieces of information when he starts that interview with the defendant. One is he knows that a print from the roll of duct tape found in the suitcase matches Garcia, who was arrested at the same time as the defendant for the Boston home invasion. And he knows that the defendant has offered his probation officer information about a Lawrence shooting. So that's the context of that interview.
But
3 days
this
later.
is- I'm sorry, I'm just trying, this is
Sure.
6 months later, correct?
Yes, 4 or 5 months later, September to March.
That's 6, but who's counting?
Oh, that's right. Actually, I was thinking October in my brain, but yeah.
6
So-
months after this incident.
That's right.
Here's my question, though. So Labarge, who seeks out that interview? The defendant or Labarge?
The defendant contacts, speaks to a Boston detective who I think, it's not very, very clear on the record, but it's clear that he wants to speak to it because he's told his probation officer about it. And
He
one of the
actually
things
says
is, why did it take you guys so long to come and talk to me?
And he also says during his conversation with Labarge or to Cuevas, something about, I was the one who wanted to have you here. You didn't search me out.
Right. Well, no, right, he says to Cueva, tell Labarge, because he knows Labarge is in charge of the interrogation. So 3 days after this, he's in custody at the Nashua Street Jail. He's taken to the West Roxbury District Court, and this came out at the motion to suppress. That's the second meeting with his probation officer, the second time that he discloses that he has information. And this time, he's in a lot of serious trouble because he's been arrested for the Boston home invasion, and he's being spoken to by state troopers about a Lawrence shooting. So the second time he speaks to his probation officer, he wants help with what they characterized at trial. They talked a lot about a trial, and the jury were told only that at that time he had significant legal concerns. He was clearly trying to trade information at that point for lenience in connection both with his Boston armed robbery and the shooting in Lawrence. So that's the sequence of events.
Shooting in Lawrence being this,
Yes, right, exactly this case. He has two problems. The second time that he meets with his probation officer, and that is the fact that he's been arrested for this thing in Boston, and he's being investigated by the state police for the shooting that is the shooting in this case.
Okay.
So he is an informant.
I actually agree with my sister that his status is not clear. He wants lenience.
Well, he's given information.
Being an informant, but he never.
He wants to trade information for leniency, and he extracts a promise, which you'll get to.
Right, or not.
Of
Yeah.
you're not there yet, of confidentiality in exchange for the information, right?
Right, but I don't think characterizing him as a suspect on.
Maybe that's just a label, but go on.
Right, an interrogatee, an interviewee, an informant. He's certainly not a confidential informant. I don't think that label matters. Now, as to the voluntariness of his statement to police, we begin, of course, with Detective Cueva's statement, "Don't worry," which happens at the very beginning of the interview. This statement is not conveyed to Bob Labarge, who's the agent in charge. And it's clear throughout the interview that the defendant knows that Bob Labarge is in charge. And he knows that this has not been conveyed to him. However, there are.
Wait. How do we know that he knew that it had not been conveyed? Because Labarge didn't speak Spanish?
Right. It was clear throughout the interview that Labarge, but put that aside for a second.
But was there anything that, all right, I mean, you're inferring that because it was Cuevas who said, no, do not worry, not Labarge.
Right, so that's just going to be one of my arguments is that if he had truly believed that he did not, that they had a promise not to prosecute him, it would have been consistent with that promise for him to make sure that Sergeant Labarge knew that that was the case.
how does he know that?
That's a
he didn't-
minor point, though.
How does he know that the trooper didn't know?
Well, because the detective, Carlos Cueva, did not translate it, did not say anything about it to Bob Labarge, and Bob Labarge didn't utter a word of Spanish throughout, and they obviously did not communicate at all.
The burden is on the defendant to set the parameters of the interview?
No, I'm just giving a reason, one, and I have 5 more better reasons.
I hope they're better.
Okay, perhaps that was a argument flaw on my part to lead with that. There are. May I start again? None of the defendant's conduct after the "don't worry" statement is consistent with the actions or statements of a man who believes that he cannot be prosecuted, that he can say anything he wants without consequence. And that's the standard that we have to look at here. Did he believe that? And there are 5 reasons that I say that that can't be the case. First is the fact that the Miranda warnings were given afterwards, unlike most of the other cases where a promise or an assurance is given that occurs after the Miranda. But they went over the form very, very carefully, and the detective actually made a mistake about which paragraph it was that anything you say can be used against you, but the defendant corrected him. It would have been logical, perhaps not necessary, but certainly logical for the defendant to have said, well, wait a minute, why do I have to agree to this? You're not going to prosecute me. That's just one factor. I'm not saying
But
that any of these...
you say not going to prosecute. That's not my understanding of the promise. The promise is that it's not going to be used against me, not that you're not going to prosecute me.
Well, I think that the way that the defendant has framed the argument is that the police implied that it would not be used to accuse or charge him with any serious felony. That's from pages 17 and 18 of the defendant's brief.
Right.
So that's what they're alleging.
Right, but it was essentially he sought some kind of use immunity. That was not the term he used, but I don't want you to use what I say against me. As long as it is not used in court, whatever I say to you be confidential.
Right, but he doesn't say, right. And that shows that he's afraid of Garcia, not the police, which is a later point that I'm making.
But
Well, I mean, he's...
how do you distinguish between, as long as it's not going to be used in court, you say that's only because he doesn't want it to get back to Garcia?
Yes.
Why?
He doesn't want there to be a record of it. He makes clear later, because as he says quite clearly later, as you have pointed out, Justice Botsford, I'm not worried for telling him, Labarge, and the police what I got to say. The thing was Garcia, a young man who was and he said upstairs, because they're both at the Nashua Street jail, he's afraid that man he thinks has killed 4 people. So he doesn't want Garcia to find out. And that is his principal, if not sole, interest here. Now, if I could go back to the other reasons why I think that it is not logical to conclude that he thought that this would never get out, is that the officer said quite clearly to him, although, as Justice Botsford has also pointed out, the translation was not ideal, he still conveyed the point, we're going to tell the court, we're going to tell the prosecutor what you have said to us. And he doesn't say at that point, as one might, wait a minute, you guys said that this was going to be confidential.
Yeah, but, you know, with that one, do you have your brief? What page is that on? Because Cuevas is, I agree with you, Labarge is fairly clear about that.
Right.
Cuevas, who's the one that's speaking Spanish to him.
Right, I think he says...
Less than clear. He
well-
sort of, you could say, we want to, I mean, because he says right after that, we want to help you. Where is that?
Pages 22 and 23.
What volume?
Okay, yeah.
Um,
This is in the blue brief.
right.
So it's appendix 16.
Well, no, I'm talking about my...
Oh, yeah.
I've actually block quoted it in my brief,
Okay, I'm sorry. Go ahead.
where Cueva says in Spanish, Labarge is telling you that you want that you care for yourself, that the first thing, that you want to come out well from all of what's happening.
Yeah.
And he also, I think, says something
But see, I'm at the top of 23, and you've got part of it in bold.
right.
Any information you give us now, he'd go to the court and they'd talk with the judge and the lawyer, and to say, look, the defendant came, and he gave us that, and we're going to try to help you. I mean, if you put all that together, I'm just suggesting that it is far from clear that it's going to be used against him, as opposed to it's going to be used as as evidence that this is a real cooperator, and so treat him well.
Right, but he doesn't want this to get out. According to the don't worry promise, which I by that time, I think it's fair to conclude that he knows that this is going to be conveyed to other people, to the prosecutor, to the court, and he doesn't say, no, don't do that, we had an agreement, don't you remember? not to convey it to anyone outside this room, whether to charge me or for cooperative purposes. Bottom of page 21 in my brief, Cueva said in Spanish that Labarge wanted the defendant to fill in the holes in the case, and Labarge said, I'm not going to make you any promises or any threats, but I will report to the district attorney. And this is the important part. Cueva explained in Spanish that the district attorney was the prosecutor, the lawyer who's going to be against the defendant when he goes to court. So that's Cueva conveying to the defendant, poorly, I admit, as Justice Budd found when she ruled on the motion to suppress, but adequately, that we're going to take this information and convey it to somebody else. And the fact that he does not then at that point say, no, wait, don't do that, we have an agreement, you can't, I think that's evidence that at that point, he does not believe that he has an agreement that this will either remain confidential or not be used to charge him, whichever one you want to say.
But the concern I have is that if he had brought in counsel, counsel would have said, okay, my client will give you a proffer. As part of that proffer, you'll agree that nothing he says will be used against him. You'll agree that his cooperation will be made known to the prosecutor and to the court. It wasn't a promise of, I mean, that's why I differ with you. I don't think this was a promise of non-prosecution. It was a promise that his statement would not be used against him. But I don't see why the fact that his cooperation would be made known to the court is inconsistent with it not being used against him. I mean, that's commonly what happens.
Well, I base my argument on the defendant's characterization of the statement, and I think that it could be interpreted as either. I mean, they're very vague statements, and don't worry is not the.
Isn't the overlay a beyond a reasonable doubt inquiry?
Pardon me?
Aren't we looking at this voluntariness beyond a reasonable doubt?
No, because voluntariness was not an issue at trial. We are solely looking at it. I'm sorry, did you say at trial?
No.
Right.
The issue
Yeah,
just.
we have to show beyond a reasonable doubt that his will was not overborne to such an extent that his statement was not the product of a rational intellect and a free will. No doubt about it. We have to prove that beyond a reasonable doubt. And Judge Welch found that we had.
Judge Welch's reason, at least as I read it, was completely based on what he thought was that the Miranda warnings, quote, completely dissipated.
Right, that's right. The Commonwealth is not absolutely straightforwardly, and in the brief I say I do not rely just on that factor.
But that's all I'm saying is that's what the judge did.
Yes, that's what the judge.
Saying it was proved beyond a reasonable doubt.
Right, he thought that it completely dissipated as soon as those warnings were given, and I'm not saying that. I'm saying that combined with the other factors reached that conclusion.
Okay, you've mentioned 3 factors. You still have 2 more?
Yes. The fourth one is that he didn't confess. That if he believed that whatever he said would not be used against him or would not be uttered outside the courtroom or he would not be prosecuted, he would have confessed to everything. He would have told his full involvement. And in all of the other cases, especially, the name's gone out of my head, the defendant actually confesses right there to setting the fire, to doing the crime.
Are you thinking of Bay?
Yes, Bay and Tremblay, they confess to committing the crime with which they're charged. Here he comes up with a largely self-minimizing, he sort of explains what he thinks he has to explain, but he doesn't confess to what he's actually charged with. And a person who believed that nothing would leave the room or that it would be confidential or he wouldn't be charged would not have been so careful and so precise as to not self-incriminate as to these crimes. And the fifth factor is one that I've not seen discussed in cases, but I'd like it to bring to the court's attention, and I raise it in a footnote. In his motion to suppress, he filed an affidavit that said, my statements were not voluntary because of my mental state, my mental incapacity. He never said under oath, it seems to me, or perhaps that's a poor way to start a sentence, if a defendant believed that he had a promise of any kind from the police, this will not leave this room, this is confidential, you won't be charged, the moment he was charged, he would say to his lawyer, they promised me that I wouldn't be charged. What's going on? So in his affidavit that he files in support of his motion to suppress, you would think he would say, the police promised me, and I believed, and because of that promise and because of that belief, I said what he did. He never says that in his affidavit. And Rule 13 states that all grounds have to be included within the affidavit. And the Commonwealth is not saying that it did not have notice, and I can't say there's any evidence that it would have put on if the defendant had included that in his affidavit, but I think it's more than reasonable to conclude that both in that affidavit plus the second affidavit that he files is even more general. The second affidavit that he files with his motion to exclude, all it says is my statement was not voluntary. And I think there's a good reason that that's not in the affidavit. I'm sorry, that it's not in the affidavit, is that it's not true. That's not his perception of what happened, because if that were his perception, he would have been furious that he was charged at all, and it would have been paragraph number 1, affidavit paragraph number 1, argument number 1, and motion number 1. The police promised me that this would stay confidential and or I would not be charged.
This is an unrelated question,
Sure.
but just a procedural one. This happened in 2004. He was indicted in 2008. So one question is, what happened? Why was that 4 years later? But the real question is, what happened between 2008 and 2014?
I don't exactly know. There were a lot of problems with witnesses in this case coming in and going out of the question. There's nothing in the record that answers
Yeah, no, I
that
just,
question,
it just
but
seems like, wow, that's a
I'd be happy
very
to submit a
long
letter. I
time
could have added, if you'd allowed me 60 pages, or if I had sought that, then I could have
I
included
mean,
it.
it's
But
not, it just.
I also
it was
wondered the
a
same
concern that it was
thing, and I
so
should have an
long.
answer, but I don't for you. But I will make it, make one of the claims slightly easier. I do concede that the defendant was entitled to a Di Giambattista instruction. I would very much,
So what do you say, Ms. Caddick argues, yes, and I mean, Elaine and Rousseau seem to me to have some bearing in this case, but I don't know if you agree. But in any event,
Elaine, did you say?
Allain, A-L-L-E-Y-N.
Oh,
Allain.
Okay, I was thinking about Woods and Rousseau. Both say that it doesn't matter what the reason is for the lack of a
Allain
recording.
is another one of them.
Yeah.
But in any event, why, I mean, she has an argument that it isn't harmless because, A, it was objected to, and so it has to be, and, given all the problems with the statement and the,
He doesn't say of a single statement, I didn't say that, or that's not a true reflection of what I said. He never says that. And in closing, his counsel said, they basically got it right. I'm not going to question that. So if he had said then or now, well, there was something in there that didn't properly characterize what I said, or was something that I didn't say, then he might have an argument that he was prejudiced. But there's not a single example of that. And presuming, as you have already said, the propriety of the admission of the statement, then a Di Giambattista instruction would have harmed his case rather than hurt it by asking the jury to scrutinize with extra care his statements to the police.
I'm sorry, one last
Sure.
procedural point, nothing to do with this case, but going forward, as this case, I think, reflects, using police officers who happen to speak Spanish has its own host of problems. I'm just wondering, do the state police use interpreters now?
Not that I'm aware of. They work with, as the court well knows, the state police are in charge of all homicide investigators, and they work with the detectives from the local police department. And my understanding is that to the extent that there are translators necessary, they come from the department involved. I'm not aware of, but I'd be happy to inform the court by letter.
It just seems to me that this case is sort of an exhibit about what happens when you've got somebody who isn't terribly good at it.
Well, I do agree, but thankfully, there's no argument made that anything that the sergeant wrote down in his report was not actually said by the defendant. So I think that in the absence of that, while it's true, as a prophylactic measure, it might be better in the future to have better translators than the one in this case.
That's all I'm saying. I'm
Yes,
not-
yes, there's no harm here. Thank you very much.
Thank you.
All rise.